Hello and welcome to a special interview for The Wire supported by Glenlivet Books. If an association or an individual moves a court, does it automatically lose the right to carry on public protests on the same issue? That's a question that the Supreme Court put yesterday to the Kisan Mahapanchayat. And today we ask, was it an appropriate question for the court to raise in the circumstances? Or could the court have made a serious mistake? That's the issue I shall discuss today with one of the Supreme Court's most illustrious former judges, Justice Madan Lokur. Justice Lokur, on Monday, as I said in the introduction, the Supreme Court asked the Kisan Panchayat if they had a right to continue protesting now that the matter was in front of the Supreme Court. I'll quote for the audience Justice Khanwilkar's exact words. When you have already challenged the law, why should you be allowed to protest? You choose only one option. Either you appeal to Parliament or you come to the court. You cannot be doing everything. So let me ask you, first of all, as an illustrious former judge of the Supreme Court, when a person or an association moves the court, does that preclude and negate the right to carry on protests on that issue?
Okay, well, thank you, first of all, Karan, for inviting me to your program. As far as your question is concerned, I'd like to break it up into a few parts. One is that an individual goes to the court. Take the case of farm laws, right? If one individual farmer goes to the court and says that I want to challenge the farm laws, does it preclude all the other farmers in the country from protesting against the farm laws? I don't think so. Does it preclude that one individual farmer from protesting? I don't think so. The Constitution does not say, there is no law which says that, listen, if you go to court, you can't protest. Why can't somebody do both the things? Freedom of expression, freedom of assembly is a constitutionally guaranteed right. So even if one individual goes, it makes absolutely no difference. If he wants to protest, he can protest. Certainly, he cannot bind all the others. That's one aspect. The second aspect is supposing an organization goes. Now, that organization, if it purports to represent all the farmers in the entire country, I think it's being a little facetious. You can't have one organization representing all the farmers in all the parts of the country. So again, its members can be told that, you can't ride both the horses. My answer is the same. Why not? Okay, there's no law which prohibits that, and certainly it does not bind anybody else. So others can also protest. So therefore, whichever way you look at it, whether an individual goes to the court or whether an organization or an association of persons goes to the court, there is nothing that prevents that person or that organization from challenging the law and also protesting simultaneously. You have a third category of public interest litigation where some third person who's not even a farmer challenges the laws in public interest. Whom is that individual representing? He's representing the people, which means the entire country, theoretically. Why can't the farmers protest if they want to? And say, all right, you can fight the battle for us in the court, but we still have a right to protest. So I don't think, whichever way you look at the problem, I don't think there's anything which prevents a person from going to court and also protesting against a law which that person believes or that association believes is unconstitutional.
This is crystal clear, Justice Lokur. You said whether it's an individual who goes to court, whether it's a PIL put by someone who purportedly claims to represent the country, or whether it's an organization that purportedly claims to represent all farmers, in all three categories, that does not preclude other individuals, other groups, other people protesting. That's perfectly clear. And in fact, I noticed that this is precisely what Chief Justice Bobde said in December 2020. And ironically, at the time, he was in fact addressing farmers in court, perhaps the same farmers. His words were, We clarify that this court will not interfere with the protests in question. Indeed, the right to protest is part of a fundamental right. Doesn't that mean that in less than 2 years, the question the Supreme Court raised on Monday suggests that the court is in danger of taking two completely contradictory, polar opposite stands on the same issue?
Yes, look at it slightly differently. What has been said is actually not a part of the judgment. It's an oral observation, okay, which is what the judge feels. But it is important. It carries a lot of weight. Why does it carry a lot of weight? Because a sitting Supreme Court judge is saying it, whether it's the Chief Justice or some other judge, it carries a lot of weight. So even though it is not a part of a judgment, and because it carries a lot of weight, there cannot be a contradiction. Otherwise, everybody is confused. What are the people supposed to make of it? Are they supposed to say that, we can't protest? Another section will say, why can't we protest? Some other judges said you can. What is the state or the establishment to make of it? Supposing they want to go and break the protest. The protesters will say, who are you to break the protest? In fact, the establishment itself said, listen, we can't break the protest because it has been said by a sitting Supreme Court judge that is perfectly valid. So, it just generates confusion, if I may say so with respect. When two judges of the Supreme Court or two benches of the Supreme Court take two opposite stands, it causes confusion in the minds of the litigants, it causes confusion in the minds of the state.
So even though these two comments, Justice Bobde in 2020 and Justice Khanwilkar on Monday, are only obita dicta, nonetheless, you're saying they need to be clarified. You cannot have judges saying contradictory things. It sends out a confusing message. It leaves the people not sure what the position is. Therefore, even if it's obita dicta, i.e. a spoken comment, not a written judgment, it still must be clarified.
Yes. And I would say that it's not only the people who will get confused, it's also the government that will get confused. What is the government supposed to do? Are they supposed to say that, no, this protest is illegal? Or are they supposed to accept it and say, yeah, it's legal? It's legal because Justice Bobde said so. It's illegal because just some other judge said so. Yeah, I mean, it's just confusing everybody, on both sides.
Now, there's a further element here that I want to clarify with you. It wasn't the Kisan Mahapanchayat that actually moved the Supreme Court on the farm laws issue. That, I believe, was done by a PAL. What the Kisan Mahapanchayat did was to go to the Supreme Court in protest against the police not giving the Mahapanchayat permission to stage a separate demonstration at Jantar Mantar. Now, these are clearly two different issues. But the court, or at least in the comments made by the judge, they seem to have been confused and merged into one. Was that a mistake to merge these into one when they are clearly two separate issues?
Yeah, it is an error. You see, you can't, in one case where you're dealing with the validity of an order passed by the police, make an observation with regard to something else which is not before you. I mean, it may be before you in some other case, but then keep it separate. Why did this Kisan Mahapanchayat go to the court? They said, we are not a part of, at least they seem to have filed an affidavit, saying we are not part of the protesting farmers, right? We want to protest against the farm laws. We want to go to Jantar Mantar and protest against the farm laws. The police said, no, we are not going to give you permission. They say, why? The police give a reason or they don't give a reason. If whatever reason they give, if they're not satisfied with it, the Mahapanchayat, they go to court to challenge that decision or the refusal to give permission. That should be decided. That are you satisfied as judges? Are you satisfied that the grounds given by the police are valid? Are they justified? If not, strike it down. But whether somebody else is on a protest somewhere else and therefore you collaterally are brought in, I don't think that's fair to the Kisan Mahapanchayat.
I just repeat two things.
That is not why they came to the court. That's not why they came to the court.
I'll just repeat two things you said. A, you said this is an error, and B, you said this is not fair to the Kisan Mahapanchayat. The court erred in amalgamating into one issue what are two clearly separate issues. There is a second issue also that I'd like to put to you, Justice Lokur. The court, through its question, is suggesting that you can't protest once the matter is before the court. But on the other hand, the court seems to be in no hurry to conclude the matter that is before it. More than 6 months have passed since the committee appointed by the court presented a report in a sealed envelope. No one knows what that report says other than the judges who received it. The judges have done nothing about it. As Labour would put it, they've effectively sat on it for 6 months. Is it therefore fair to stop farmers from protesting when you yourself don't seem to be in any hurry to conclude the matter?
Yeah, well, all I can say is it's very unfortunate, for two reasons. One is, like you said, sitting on the report for almost 6 months. I think it was given in March, so maybe about 5 or 6 months. At least open the report, let the people know. I mean, some persons whom you have appointed to look into the matter, they've given a report. At least give them that much of, importance that yes, you've given us a report, we'll have a look at it. We may not agree with it. I don't know what the report contains. We may not agree with it. We may disagree or whatever. That's one aspect. The second aspect is that the farm laws were challenged by somebody, maybe by farmers, maybe by somebody else. How about deciding them? Now you have this Citizenship Amendment Act, for example. Protests all over the country. Okay. The cases were filed 3 or 4 years ago. Why are they not being decided? And then, people are told, no, you can't protest. So supposing the Supreme Court doesn't decide it for the next 10 years. So for 10 years, you can't protest on it. What happens?
That is a very good example you raised. The CAA, the Supreme Court has the matter before it. It's not hearing it. It's clearly, as layman would say, dragging its feet over the matter. Therefore, if the Supreme Court's position to the Kisan Mahapanchayat is to be taken to its logical conclusion, it means no one can protest over the CAA. And if the court takes 10 years and more to hear the matter, then you can't protest for 10 years and more. And clearly, that is not just unfair. It would look injudicious to many, and it would seem illogical to many. I think you put that very well. Just to clarify, sir, the sealed report was given to the Supreme Court in March. Therefore, today being the 6th of October, we're just over 6 months since it was presented.
Yeah.
Now, there are two other issues, Justice Lokur, that arise because of questions that were asked by Supreme Court judges on Monday. First, the Supreme Court asked, have you taken permission of the citizens living nearby? Is such permission necessary? And if that wasn't taken, or if the citizens didn't grant it, does it make the protest illegal?
You see, as far as I'm aware, and please correct me if my information is incorrect, the farmers who are protesting wanted to come to Delhi and to protest on the Ram Leela grounds, right? Where so many protests have taken place, India against corruption was there. They have been stopped from coming to Delhi, all right? They've been told you can't enter Delhi. So what are they supposed to do? They have two options. One is go back home and say that, we can't enter Delhi, so therefore we can't protest, so we might as well go home. That's one option. The second is say, all right, you're not letting us enter Delhi, we'll protest at the border. What do? They chose the second option. They said, we are going to protest at the border. Now, if the people in that area are inconvenienced, they're being inconvenienced not because of the farmers protesting over there, because the farmers have been compelled to protest over there. if the farmers had been allowed to come to Ramlila grounds, these neighbors would not have been inconvenienced. So how can you blame the farmers for this? You tell a person that, listen, I'm not going to let you enter. And then you say that because you're outside, you're causing problems to somebody else. I'm sorry, it doesn't make any sense to me.
And it also therefore follows from your answer that there's no need to either seek and require and obtain the permission of citizens living nearby. That's an irrelevance.
Yeah. Right. In fact, the police should have, said that, listen, do you mind if these farmers protest over here? The police should have taken permission. Why the farmers? Because the police have compelled the farmers to be there.
Absolutely, sir. Now, there's a second issue that arises, again, out of questions raised by the Supreme Court on Monday. The Supreme Court said it wants to examine whether the right to protest is an absolute right. As someone who's been one of the most illustrious Supreme Court judges of recent times, what's your answer to that question? Is the right to protest an absolute right?
It's not an absolute right in the sense that there are some checks and balances that are given in the Constitution. Right? You have a right to protest. You have a right to assemble. Okay, you can assemble for a protest. There are some checks and balances that are there in the Constitution. Now, surely, when it was debated in the Constituent Assembly, the members of the Constituent Assembly knew what they were doing. But if you try to subvert that right, through some other means, then there's a problem. You had mentioned, Karan, about inconveniencing the neighbors. All right. Now, it appears, again, correct me if I'm wrong, it appears that when the Shaheen Bagh protest took place against the Citizenship Amendment Act, the police had blocked some roads for the purposes of diverting traffic. And the blocking was done in such a manner that there would be a traffic jam and the commuters would get harassed. Okay. And that harassment was then said, because of this protest, these people are being harassed. These commuters are being harassed. But what is the reality? The reality is that those barricades were put up by the police so that they create the situation. You've had occasions in Delhi when metro stations have been shut down. Why? Isn't that inconveniencing people? And who has shut down these metro stations? It's not the protesters at Shaheen Bagh. They did not do it. They can't. They don't have the authority or the power to do it. It has been done by the state. So it is the state which has caused inconvenience when they close down metro stations.
I want to take up in a moment's time the very important point you just made about how the state blocked roads by closing off entry and exit points and tried to blame it on the farmers. But before I come to that point, just to clarify on this big question of whether the right to protest is an absolute right or not, are you saying that the fundamental basic check is that it must be a peaceful protest, i.e.
Yes.
within the laws? But if it is peaceful and if it is within the law, then it is a right.
You're right. Peaceful and without arms. That's what the Constitution says.
In other words, a peaceful protest without arms is legitimate and legal and constitutionally valid and cannot be stopped in a democracy.
Yeah. Should not. I mean, unless there's, good enough reason, sustainable reason that this group is going to cause mayhem, then perhaps permission can be refused.
Can I put one other point to you, and I make it as an anchor rather than someone who's a lawyer? But to me, it seems that the right to protest makes effective the right to dissent, the right to disagree, the right to differ. In fact, you could even argue that it makes effective freedom of speech. Because if you can't protest about what you don't like, and I admit it has to be done peacefully, then freedom of speech, the right to dissent, the right to differ, the right to disagree all become ineffective. So in that sense, it's a very important right.
Correct. Absolutely. Absolutely. I'm 100% in agreement with you. You see, there are various forms of protest. Okay. I'm a literate person, so I write and I protest. Okay. I'm an illiterate person. I can't write and protest. So what do? I get hold of another, maybe 100 people like me who are illiterate, and we have a dharna or something, or a sit-in or something. What's wrong with it? So it is my form of expressing my disagreement or my dissent.
And sir,
And as long as I'm doing it, and as long as I'm doing it peacefully, you can't stop me.
in fact, you've made a very important point, Justice Lokur. In a country where literacy perhaps is limited to 70%. And by the way, I'll just add for the audience, often literacy is judged not by ability to write properly, but simply by the fact you can sign your name. And therefore, that's not really literacy, even though the government claims it's literacy. But anyway, in a country where literacy is limited to 70%, the right to protest becomes even more important, because it's the only way you can indicate to the government or the state or the authorities that you disagree. And therefore, to curb it means that 30% at least who are not literate are suddenly denied the right to dissent and disagree and to make that known.
Correct, absolutely right. Yeah, I'm in entire agreement with you.
Let me then come to the point you made about how it's the police, the state, the authorities who often put up blocks on entry and exit points, thus creating problems for traffic, problems for people movement, but blame it on the farmers. This was a point that refers to what happened in the Supreme Court, but to a different bench of the Supreme Court on the 1st of October. That bench said to the farmers, you have strangulated the entire city. The farmers' defense is that it's not us who blocked the roads. It's the police who put barriers on entry and exit points to give our movement a bad name. Yeah. Now, my question is simple. Judges are meant to be discerning. Judges have a duty to be accurate. Surely that bench of the court should have made some effort to ascertain the truth before it pinned the blame solely on farmers.
Right. You're absolutely right on that. You see, I don't want to go into history, but one of the reasons why the Supreme Court was considered to be the most powerful court in the world is because it was the people's court. People came first, right? Now, what does the Constitution say? The Constitution says that it guarantees to me the fundamental right. And if somebody tries to violate that fundamental right, I can go to the court and say that, listen, please protect my fundamental right. That's how it becomes the people's court, where it starts protecting the fundamental rights of the people. But when you assume that the people are strangulating the city of Delhi without ascertaining whether the people are doing it or whether the state is doing it, you kind of deviate from being a people's court. And that's where the problem is. The state becomes important, not the people. What is important for our constitution and for our courts is the people. And the moment you say that, well, you're there, good enough, but I think somebody else is a little more important than you, there's a problem.
In layman's language, what you're saying, Justice Lokur, in making that comment to farmers, you have strangulated the entire city, the court gives the impression of siding with the state against the people. And that undermines the belief that this is a people's court, which is the basis on which our Supreme Court becomes perhaps the most powerful Supreme Court in the world. But secondly, if you give the impression of siding with the people, with the state against the people, then you're becoming partisan. And that also affects the image of the quality of justice you give.
Not necessarily, because here the comment has been made. I mean, I'm assuming it's an off-the-cuff comment, because there has been no basis for coming to the conclusion that if Delhi has been strangulated, it is only because of the farmers. It could have been strangulated because of blockades by the police. Right? So you have to get both the facts, what exactly happened,
Absolutely.
and then come to a conclusion.
Absolutely. The judges should have the facts, know what's happened, and then seek to pin blame or make comment rather than to do so without having the facts clear. Finally, we're coming right to the end of this interview, Justice Lokur. I want to put to you a point made yesterday in the Indian Express by Rekha Sharma, a former Delhi High Court judge. She says the Supreme Court is being very uncharitable to the farmers. That's an exact quotation from her. She says, and again, it's a quotation, there's no empathy for them. And finally, she says, they're not being treated with the dignity and respect they deserve. Would you agree?
Well, this is where the people's court concept comes in. You know, these farmers are not foreigners, you know, and they're not enemy people. They're Indians. Okay, they have a grievance. The grievance may not be legitimate, but hear them out. You know, instead of saying that, listen, you are the cause of strangulation, you are the cause of you know, problems. How do you know? You know, if you don't hear them out, so many cases come to the court. It doesn't mean that every case is a good case. Some grievances may not be legitimate at all. That's why they get dismissed. So it's possible that the grievance of the farmers is not legitimate. But don't, you know, go on the assumption that, oh, you know, you're causing a problem. You know, so many people are being inconvenienced, and commuters, I mean, of all the people, commuters are being inconvenienced. What about all the other traffic jams that are taking place in Delhi? So, you know, blaming them, you know, with a sort of an ex-cathedra statement, I think should be avoided.
So I want to pick up very quickly on something you said. You said, don't go on the assumption. And then you said, blaming them with ex-cathedra statements that should be avoided. Those are not things one expects from judges. You expect judges to be very conscious of actually being objective, putting their assumptions aside, relying only on facts, and completely avoiding ex-cathedra statements. That's what judicial training makes a judge very conscious of. Isn't it sad that you, a former judge, should have had to make that comment about people who are fellow brother judges? I'm not asking you to be personal about them, but isn't it sad that this has to be said?
Yes, I mean, it is sad. I can't say I'm very happy at these statements. It is sad. And you see, the thing is, judges are responsible people. Okay, whether they are at the High Court level or at the Supreme Court level, they're all responsible people. And the situation is delicate. You know, just handle it with a little bit of sensitivity.
Right, sir. It's a delicate situation. It should be handled with sensitivity. Justice Sharma of the Delhi High Court said, with empathy, I take it that sympathy and empathy are synonymous terms in this situation. I thank you, Justice Lokur, for this interview. I thank you in particular for very clearly and forthrightly laying out the situation and making it clear that whether it's an organization, an individual, a PIL, that does not preclude the right of other people to maintain and continue peaceful protests on the same issue, regardless of going to court or not. That is very important because I think it clarifies the situation for everyone. Thank you, sir. Take care.
Thank you.
Stay safe.
Yeah, thank you. All the best.